Hello and welcome to the Your OKC Property Manager podcast. Today's episode is titled Ask a Real Estate Attorney Your Biggest Oklahoma Landlord Legal Questions Answered. And this is Scott Nachatilo, and I'm the broker and owner of OKC Home Realty Services. And, we're a property management company in the Oklahoma City area. And I'm here today with Darren Barr, who is a real estate attorney. So, Darren, thanks again for joining me on the podcast and sharing your knowledge about legal things in terms of real estate. Can you kind of tell me, how did you become a real estate attorney?
Sure. And Scott, it's great to see you today. So, how I became a real estate attorney is actually a pretty easy question to answer. Okay. Originally, way long ago, I went into law school and I was like, you know what I want? I'm going to be a prosecutor. That's what I'm going to put people in jail. I'm going to make the justice system good. And then I had the pleasure of taking criminal law as a law school course. And oh boy, that is some nonsense. So I decided, you know what? That is not what I want to do. And ended up getting into oil and gas law. Oil and gas law is real property law. It's the same thing roughly. And then eventually I transitioned out of oil and gas law into now real estate law, i.e. houses, real property, transactions.
Okay. So can you get a little more detail into what exactly does a real estate attorney, what do they do? What do you do?
Sure. Yeah. So a real estate attorney, okay, my main clientele are realtors. So I deal with any issues that realtors deal with, but I deal with it more on a legal basis. Okay. I advise realtors, brokers, landowners in Oklahoma. It can do anything from contract review to purchase contracts, contract for deeds. That's always a common one. And then, of course, landlord tenant issues, right? So evictions, that kind of thing, leasing, commercial leasing agreements. That's sort of what my firm deals with.
Okay. So I've got some more specific questions for you to kind of get a little more detail into how these things kind of fit together. So in terms of someone owns a rental property, what's the ideal legal structure for them to own that property?
Sure. So number one, okay, if you're going to own a real estate, like a rental property that you yourself are not going to live in, it needs to be in an LLC. Okay. At least a bare minimum. And LLC is a limited liability company. Okay. Under Oklahoma law, they're actually super easy to make and create and do all of that. The predominant reason about why this limited liability company is so important is it's in the name. It's limited liability. So if you do everything right and you don't commingle assets and if you do everything right, essentially what it does is it will separate that rental property and make it its own asset. So, for example, if you own rental property and the tenant sues you for whatever reason, that tenant will only be able to get to the assets of that LLC, namely the house that they're currently renting, right? They wouldn't be able to get to your personal bank accounts, your personal home, your car, your investments, that kind of thing, right? They would only be able to get to that specific home. And so that's what a limited liability company is. And right now, if you are renting a property and you own the property, it needs to be in an LLC. Okay. Go look up on the Secretary of State how to make that. It's super simple. You can do it literally while we're sitting here talking. Okay.
Okay.
So that's the best one, LLC.
And so I guess you're saying that's better than just having it in a trust. A lot of people own property in trust.
Right. Well, yeah, and you want multiple LLCs. So if you own multiple rentals, those should each be in their own LLC / with new recent laws in Oklahoma, you can actually create what's called a series LLC, okay, which is essentially a bunch of separate LLCs. But you can create a series LLC, and each property needs to be in its own LLC, okay? That's to separate and, again, limit your liability, right? You do not want it in the trust that your own personal house is in because guess what? That doesn't limit liability, right? They can still get to the trust assets. LLC for sure is the way you want to go.
So just in terms of like when we have a tenant in the property, what kinds of clauses should be included in that lease just to ensure that, that the rental property owner is like protected from things like, non-payment and, lease violations and things like that. What kinds of things would you recommend?
Sure. And I'm going to reveal a little industry secret here, okay, Mr. Scott? So there is the OREC lease, right? The Oklahoma Real Estate Commission lease, right? That's what realtors use when they take tenants to lease. And that is sort of a customary, lease, right? If we're going to go outside of that lease, some of the things we need to consider is number one, damages, right? That's always the big landlord tenant concern, right? If tenant comes in and destroys the property, what happens? Obviously, that means we need to have a security deposit, right? It's very rare that you'll find a landlord-tenant relationship without a security deposit. It does happen. It does happen, especially in college towns. So like Norman, okay, for example. But you really want to have that security deposit as security, right? For any damages that tenant may or may not do, right? And then secondly, another thing that I really, really make sure is in leases, right, is all the payment terms. This sometimes catches landlords where they essentially say, hey, tenant, you have to pay me $1,000, whatever, right? But then give no ifs, ands, or buts about how to do that. Do you have to mail the check? When is it due? If I send it to you and it comes in the second, do I get a late fee? Right? All that kind of stuff needs to be included in sort of a lease agreement. Obviously, any sort of repair, maintenance requirements by tenant, right? That needs to be in there. And then finally, some of my favorites that I've had to deal with recently is sort of danger provisions, is what I like to call them. So if the tenant or a guest of the tenant is a danger to the property, to other tenants in the area, to, anything like that, then they can be immediately evicted. That's essentially what Oklahoma law says, but it needs to be reiterated in the contract to say, hey, look, if I'll give you an example. One of my clients came to me probably 2 months ago where a tenant had started a fire on the porch, like a whole campfire, right? Fire, police, everybody call it. And it's like, okay, yeah, no, that's a danger, right? Not only to themselves, right? They could have caught the house on fire, but to the house itself, right? And so that's kind of an immediate eviction sort of provision, right? That like, listen, we can't be waiting for a month. We can't do the 30-day notice, right? They need to be out now. So we're talking, make sure tenant knows how and when to pay, right? Make sure the tenant knows of their duties and responsibilities. And then, finally make sure that you have some sort of danger provisions, that kind of stuff, right? And again, security deposit.
Kind of looking outside of the lease agreement, sometimes there's things that we do, as property owners that maybe we kind of don't use common sense, or sometimes we make mistakes that can cost us. What are some things that we should avoid so that we don't like attract lawsuits as a rental property owner?
As a property owner, the quickest way you attract lawsuits, okay, is failure to repair. All right, that's number one. All right. The tenant tells you, hey, look, the front steps are broke. You need to come out and repair them. Landlord doesn't for whatever reason. Tenant trips and falls on the stairs and breaks something. Oh boy, now you're getting sued, right? And it technically landlord your property. They notified you need to repair, and you have a certain amount of time to repair under Oklahoma law. And then, failure to do that is kind of this sort of negligence argument, right? So that's number one, right? Is sort of this failure to repair. Lately, I've seen an increase in sort of fair housing violations as well. So that's wherein a landlord who does not use a company like Scott's over here will lease only to specific individuals or a specific set of the population, or will only lease to people above the poverty line or something like that. That's all fair housing violations, right? So all equal due consideration needs to be given for everybody. A common one that has popped up recently is gender. So some landlords will only lease to single women or something, right? That's an issue. We need to avoid doing things like that.
We have a lot of discussion about fair housing, and kind of the baseline rule of thumb is to treat every applicant, every tenant the same, or you start running afoul of fair housing laws.
Yep, exactly, exactly. And then finally, something that really gets landlords into trouble nowadays is you have to be very careful with security deposits. Okay. Um, we'll go over the rules and requirements later, I think, but essentially, we need to make sure that as a landlord, you're keeping those security deposits separate. They're not being spent until the end of the tenancy, that kind of stuff. Because there, of course, are fair housing, failure to repair, and then, of course, issues surrounding the security.
Anything regarding insurance to kind of help bolster the protection of the property owner?
Well, so we come back to the LLC, right? Your LLC should own the property, and your LLC should have general liability insurance. Okay, that's super, super cheap. Talk to your local insurance guy. If you don't have one, give me a call. I know one. It should be really super, super cheap for sort of general liability insurance on your LLC. That protects you against sort of lawsuits. You should also, in your lease, here's another little tidbit. You should also require that your tenant has tenant insurance. Okay. Tenant insurance covers their belongings in the case of like fire or I think so even like a breaking and entering, they steal stuff. I think some insurance policies cover that as well. But you require that of your tenant because it's like super, super cheap. It's like $10 a month, maybe. And it also solves that issue in the event of some sort of catastrophic, like let's imagine your rental property catches on fire and burns down not only the property, right, but also all of the tenant's belongings inside the property, right? So you as a landlord could be potentially liable for all those belongings, right? Which is why you require your tenants to get this tenant insurance. And then finally, also speak to your agent there, your insurance agent or whatever, about landlord riders and endorsements. So there's actually specific little policy add-ons that you can get for landlords, right? And that could cover a number of things like rents and all kinds of other stuff. Okay, but there are specific insurance that you should look into if you are doing this sort of rental thing as a business, right? But again, general liability on your LLC and your tenant should also have insurance at bare minimum.
Okay, great. Yeah. Yeah, we're gonna just kind of move along here and talk a little bit about evictions. So can you kind of walk us through the process of doing an eviction in Oklahoma? Let's assume it's something like for non-payment of rent.
Yeah. Failure to pay rent is like number one. Luckily, it's pretty easy in Oklahoma to do an eviction. Okay. You don't even have to have an attorney for it, technically. I always recommend because, hey, I am an attorney. Essentially, the first step, obviously, is there has to be some sort of breach, right? Tenant needs to breach the contract, the lease in some way. 99% of the time, that's rent, right? They fail to pay rent. And so you'll give them a notice, right? This notice needs to be posted on their door, mailed to them by certified mail, all that good stuff. And the notice changes depending on what the breach is, right? The most common is your 5-day notice, right? That's the failure to pay rent. So rent's due on the 1st. You wait till the 5th, then give them the 5-day notice and say, hey, look, pay rent in 5 days or get evicted. After that notice to quit has been provided, and there is requirements to that, specific needs to be mailed and that kind of stuff. Then you file your evictions, right? So you go to the court clerk and you get a small claims affidavit, or some will actually call it a forcible entry and detainer. Okay, FED case, which is eviction. It's an eviction case, and fill that out. Once you have that filled out, the affidavit is filed in the court. And then you have that affidavit served. You can either do a private process server or by a sheriff. Most of the time in evictions, I always have the sheriff because you know where they live, right? So it's not, you don't really have to go do any sort of searching or anything like that. And generally the sheriff will get it done after the service is good, right? After you actually get them served, you go to court and you argue it out. Okay. You say, hey, look, they executed this lease for this amount. They didn't pay me this month. Hey, look at my ledger, right? That kind of stuff. After the court hearing, if if the landlord is successful, right? They'll get what's called a writ, okay? If required, but they'll get a writ, and that will essentially tell the sheriff to come out there and lock the tenant out in 48 hours, right? If the statute says 48 hours, it's almost more. It's almost always more. Like Oklahoma only does lockouts on like Tuesdays and Thursdays, I think now. So, if you get it on a Friday, you don't get it till next Tuesday, that kind of thing, right? And I know, like Cleveland County, they require you to hold it for 48 hours, and then you can come back and file the writ. So there are little intricacies to each court, right? But I mean, really, it just comes down to notice. You file the case, you give service of the case, right? You notify the tenant of the case, and then you go to court.
I know you're saying that it's a simple process. Have you ever seen a landlord representing themselves in court that ends up making a mistake that they have to start over? Have you ever seen that happen?
100%. It is a simple process, but it is a legal process, okay? So the statutes are pretty clear about what you need to do. But if you don't follow exactly that, then, well, you're out of luck, right? So, for example, a 5-day notice is a 5-day notice, right? I've seen an individual who came in and represented themselves and gave a 5-day notice for failure to pay, right? The tenant had paid on like X day, and then they gave a 5-day notice. And so that like 2 days of that 5-day notice technically overlapped for a period that they were not actually in breach of the contract, right? They were not actually in breach of the lease. And the judge said, hey, guess what? Your notice is not sufficient because you only gave a 3-day notice, right? Not a 5-day, because they were good for those 2 days, right?
Yeah.
So boom, dismissed. I'll see you back next month whenever you actually do it correctly, right? So it is easy, but it's legal easy, okay? So be aware that everything has to be exactly as so. And if it's not, then, well, yeah, you have to retry. Essentially, you have to go back and refile it and pay all the court costs and all that kind of stuff again. So
Yeah, our company, we could, and we used to file our own evictions and take it, but ever since COVID, things have really kind of tightened up, and we just don't represent ourselves. We always have a real estate attorney to do the courtroom process, for us. Kind of mentioning COVID, have there been any other kind of recent changes in laws or regulations that have affected the eviction process?
yes, so there was that moratorium for a while during COVID, right? All that has ended. Okay. There for a while there were like CARES funds and stuff that you could get that would help a tenant pay for some rents and that kind of stuff. But all those programs are ended, to my knowledge. It's actually interesting you asked that because what is it? I think it's Senate Bill like 128. I think it actually just passed both chambers, right, and is now sitting on the governor's desk and may already be signed by the time we're talking here. But essentially sitting on the governor's desk. And what this does is it actually extends the time frame for an eviction. So no longer is it the 5 days. I think they're adding an additional 5 days. Okay, so it'll actually be 10 days, right? Now, I don't know how much that will actually affect in actual process and that kind of stuff, because generally it takes a little longer than 10 days to do an eviction, but not all the time. And then I also know that there have actually been recent claims for pushing to increase the cost of filing an eviction. Okay. And it kind of makes sense because the common use of an eviction right now is sort of a threat to pay rent, right? It's like, hey, pay rent. And then, you file the eviction. Oh, you ready to pay rent now? And the Senate and all that kind of, they see that this happening as sort of, it's more of it's more of a cane rather than actual legal process. And they say, well, let's, increase the cost. And it's like, well, on one aspect that may work, maybe, right? But on another aspect, it's customary nowadays that the tenant pays all of those court costs and, attorney's fees and all that kind of stuff, even if the case is dismissed, right? Those are tacked on to the ledger, right? So we have to be careful about increasing the cost because, well, that may just go through and increase it on the tenant, right? Not all the time, but maybe, right? But nothing has been passed as to that issue. But there has been a recent bill that has been passed and is waiting on signature that increases the time frame of an eviction, so it makes it extend it out a little.
Right. Okay. What is an eviction generally cost an owner these days to do like a residential eviction?
Yeah, well, like we were talking, this may not be true in next month, right? They may change the law. But right now it costs about $58 to file, assuming the tenant doesn't owe a crazy amount. The tenant owes more than 5,000, I think, is what it is. Then it costs more. But generally, $58, and then it's $50 for the private processor / sheriff, and then obviously your time and effort, mailing costs, that kind of stuff. Honestly, you have to take small claims. Okay, so that's what an eviction is small claims. So wherever you're going to go is going to take all day. Okay, so just take the day off of work. All right, to go to these small claims evictions. So I mean, the monetary cost is not too crazy. Again, you're probably talking $150, but it's the time cost. Okay, that's the real issue, because you'll have to be in that eviction court for at least half a day, if not more. Okay, so
Yeah, I guess.
about $150, and
And the legal fees if they're using someone like you to take care of it for them.
yeah, legal fees on those. It depends, right? For whatever attorney you choose. Don't expect probably another $150, $200. I might be underselling a little bit. I know some people charge like $400 for an eviction, that kind of thing. But it again depends on the attorney. Depends on that. But yeah, I mean, you're probably talking the same amount of your costs, if not a little more.
What sorts of things can a landlord do to just like maybe not necessarily completely eliminate, but greatly reduce the chances that they'll actually have to go through with an eviction?
Yeah, I mean, number one, and Scott, this application, right? Vet your tenants. Simple as that. Don't just accept somebody who walks off the street and says, "Hey, look, I want to be your tenant." Well, do you have a job? Do you, what's your name? What's your birthday? Where, that kind of stuff. So application, right? You need to have some sort of application for tenants to fill out, right? That application also provides all the information you need for later on, just in case you do come to an eviction, right? You need to know their birthday. You need to know that kind of stuff, right? But yeah, number one is application. You got to vet your tenants. Something else that you can do yourself as a landlord, right, is to go check OSCN. It's the Oklahoma Supreme Court Network website, right? OSCN. And you can search the tenant's name in there, and it'll show if there's been any other evictions or judgments or small claims or lawsuits or, criminal activity or anything like that in the state of Oklahoma. So, I mean, obviously, if you go in there and you see that they've been evicted 4 or 5 other times, you're like, oh, well, maybe I shouldn't rent this individual, right? Because look at the history, right? Credit check is another good one that you can do. Those are pretty cheap and pretty easy to do. And that credit check will show like judgments, will show outstanding debts and all that kind of stuff. So, I mean, that number one is application. Make sure you have information about the actual tenant. You'd be surprised about how many clients come to me. What's their middle name? I have no clue. What do you mean? Who am I supposed to be giving notice to if I don't even know their name? So application, follow that with probably an OSCN search, and then maybe a credit check as well. So background check.
Perfect. Perfect. All right, let's talk a little bit about squatters' rights. What exactly are squatters' rights, and how does that differ from, let's say, like adverse possession?
Right. Yeah. So I always love this question for squatters' rights. The answer is quite simple in Oklahoma. There are no squatters' rights. That doesn't exist. Okay, that's a falsity. Other states may have it, California, some of those or whatever. They may have some sort of squatter rights. In Oklahoma, no, right? You are trespassing. If you are not supposed to be there, it is trespassing. It's criminal. Call the cops, all that good stuff. Adverse possession, on the other hand, is more of a legal argument. Essentially, adverse possession requires 15 years of possession. So it's not something that you're going to run into as a landlord, right? I hope that you've been to your property at least once in 15 years, right? To at least look at it. But so adverse possession essentially says like, hey, if somebody comes in and lives there for 15 years, it's theirs, right? but yeah, that's not squatters' rights. That doesn't allow some random group.
That 15 years is kind of the time frame then that they would have to occupy the property before they could really claim, like they claim ownership. Is that right?
Yeah, but yeah, you claim ownership. It's still still have to go through a lawsuit and adverse possession and all that kind of stuff. But yeah, it's 15 years. So the random person who broke into your rental and is now living there, that's not squat. They don't have squatters' rights. That's not a thing. You call the police, right? And if the police or the sheriff doesn't remove them from the property, then you may have to file an eviction. Unfortunately, okay. Your eviction will be pretty easy, right? They have no legal standing to be there. But a lot of times, sheriffs or police will not actually remove somebody from the property without a writ, without an actual court order or eviction, right? Because the police don't want to get in trouble, right? They don't want to evict a legal tenant because of the landlord said so, right? So I get where the police are coming from on that. Some will, some won't. Just depends. Okay, just you have to call the police anyways because they were technically trespassing and committing a crime. So hey, document it. Right? But yeah, I mean, number one is if there is a squatter there, call the police. And then number two, yeah, you may have to file an eviction, but there are no squatters' rights in Oklahoma.
Okay,
It does not
makes sense. Okay, so we talked a little bit about security deposits. Let me circle back to that. So what are the legal limits and rules for collecting and holding security deposits in Oklahoma?
Okay. So this is so the exact law is 41 OS like 115, I think. Okay. And this applies to residential security deposits, okay, specifically. But essentially that law states that that the security deposits have to be kept in a separate escrow account. Okay. And it specifically says escrow in the statute. So it cannot be your separate savings account. It needs to be an escrow account. So that's number one, separate escrow account, right? Has to be at a FDIC insured bank, which most banks now are, but it can't be buried in the backyard. Okay. That does not work. And then, if there is some sort of misappropriation of those funds, right? Or perhaps maybe you didn't keep them in an escrow account, or perhaps, you're bankrupt or whatever. Well, guess what? It's a crime. Okay. I think it's 6 months in jail, I think, and a fine. So it's literally a crime. You can actually go to jail for failure or misappropriation of this security deposit. Okay. So it is a big, big issue. All right. Specifically because it is a crime. If you're no longer liable to the tenant, you're liable to the, district attorney. Right. But the number one thing is that it needs to be kept in a separate escrow account. And it needs to be not misappropriated. So you need to make sure you account for every single cent, essentially, of those funds. Yes. So yeah, that's the number one requirement is escrow account.
So once a tenant moves out and the property manager or the landlord does their walkthrough, they identify some damages that were done to the property. What are the requirements for kind of reconciling what to do with that security deposit once we have that information, like the determine what the damages were, and things like that.
Yeah. So first, right, if the tenant is moving out, okay, they should provide the landlord a written demand, okay, for that security deposit back. The landlord will then have 45 days per the Landlord Tenant Act, right, to investigate and then to return that security deposit. If the landlord withholds any of that security deposit, okay, i.e. for damages is the most common one, right? They need to provide the tenant with a ledger, a statement that is clear, concise, that says, hey, look, this is broke, this is broke, this is broke, this is broke, this is how much it costs to fix it, and this is how much you're getting back, right? So if you're $1,000 and it takes $800 to fix something, then you get $200 back. Okay. And then you send back within that 45 days, the landlord would send back a check for that $200. My number one thing about this, there are two things really. First is don't very, very, very rarely don't send a ledger from yourself that you say is going to take to repair this, right? Get an actual licensed repair person. Okay, get somebody separate. Okay, that just make sure to maintain above board, right? So, for example, if plumbing is messed up, hire a plumber. Okay, to go out there and fix that. Don't do it yourself as a landlord and say, "Oh, look, a plumber would have charged me $700, so I'm going to charge you $700." No, no, go get the plumber. Okay, get an invoice from the plumber. And then my second point to this is evidence. Okay, take pictures of everything. This goes for both tenants and landlords. Okay, take pictures when a tenant moves out. Takes pictures right before tenant moves in. Right, and again, tenant, make sure you take pictures right when you move in and when the tenant moves out. Right. Video walkthrough. If anything is broke, make sure you document that. Okay, before it's repaired. Because if you don't, and then you say, "Hey, look, it was damaged," and then it's not repaired, what are you going to ship? Right? You're going to walk in the court and say, "Hey, look at this nice wall that I have repaired." You know what I'm saying? Like, it doesn't work that way. So you need to have evidence. Okay, evidence, and then make sure that you are being above board with your repairs as a landlord. Okay.
Yeah, that's so true. The only time when you kind of go off the rails in terms of the security deposit is if you don't have that evidence. Sometimes it's hard to get a photo to pick up on subtle things, like you may have to repaint a wall, but it's really hard to get a photo that shows that. And if you take that into court, it's hard to show that. So one thing,
Right. Well, video.
we've done, I think, even if we're going to have a handyman do it, we make them write on their ticket, the wall had to be repainted because even if the photo may not show that, at least you have it in writing from a professional that says it needs to be taken care of.
Right. Exactly. Exactly.
Okay, so we've got one more thing I wanted to talk about here. You know, at some point, a lot of owners decide they're going to go ahead and sell the property, and sometimes they'll wait until the property's vacant, or sometimes they'll just go ahead and they'll try to sell it with a tenant in place. Can you kind of go through, like, what's the legal ramifications of selling a property that has a tenant in place?
Yeah. So I agree. So one of the things that my clients with the landlords, they come in and say, "Hey, look, I want to sell the property. How do I evict this tenant?" That's not the correct question. Okay. That is not the way to do this. Okay. You cannot evict a tenant because you intend to sell, right? You can end a lease if it's, month to month and that kind of stuff. But the way that a sale works with a tenant already in the property, right? The buyer is purchasing that property subject to that lease. Okay. So obviously the landlord needs to disclose to buyer that there is in fact a tenant there, right? Which you can't really hide. But the buyer will take the property subject to that tenancy. Obviously, tenant then just pays rent to the new owner,
Yeah.
right? That the buyer takes over that landlord's lease, that kind of stuff. You cannot use your intent to sell the property as a reason for an eviction. Okay. That is actually retaliatory, and oh boy, I'm sure the judge would love to have a conversation with you when you get up there.
Can you terminate a lease for that reason?
Yeah, so you can't unless the lease says so, right? I mean, if the lease says, "Hey, I can terminate it within 4 days notice," or whatever, you can agree to whatever in a lease, right? Most of the time, I'm going to say 99% do not or will not say that, right? That's not customary. But what happens a lot of times is either A, the tenant is a holdover tenant. So they did have a prior lease, but now they're month to month and have been for a long time. And, the landlord just wants to sell it. At that point, you can give a 30-day notice, right? To say, "Hey, look, tenant, you're month to month. So in 30 days, we're ending our landlord tenant relationship," right? You can do something like that. But if you're in the middle of a year-long lease or something like that, you cannot evict them for your intent to sell. Okay, you have to sell the property with the tenant involved to a buyer who will buy it like that, right? That does not mean you can't evict them for failure to pay rent or something else, right? But for the sole reason of selling your property, no, right? Most of the time, 99% of the time, it's going to be no, unless your lease specifically says like, hey, in the event that we're going to sell it, you have 45 days to move out, right? Wherever you agree with your tenant on that. But most of the time that doesn't say that, right? Some other considerations there too, as well. I will put in here, since we have been talking about security deposits. In the sale, if you sell a property with a tenant in it, you have to convey the security deposit as well, or give it back to the tenant. There's two different ways. There's the statute, but most of the time it is conveyed to the new buyer for the new buyer to put it in their own escrow account and do all of that kind of stuff, right? Because technically that security deposit goes with that property, right? It is not the landlord's property. It's not the landlord's possession. So that is also an interesting point of contention a lot of times with some of these, is like what happens to the rent the month that you actually transfer the property, right? Which a lot of times it's prorated, right? So and then what happens is the security deposits, right? Whether they're waived, does tenant need to give you a new one, right? All that kind of stuff.
Well, I think that's all I've had questions for. We covered a lot of ground, I feel like. I really appreciate you coming on the podcast here today, and definitely helping our listeners kind of figure out some of these things in terms of like how to do an eviction, what's involved, protecting their investment, really, really important things, and kind of staying in compliance with the law. You'd like to reach out to Darren if you need help with one of these issues, maybe setting up an LLC, or maybe you've got a tenant that's behind.
Yep.
And you need to start looking at doing an eviction. Darren, can you tell them like what's the best way to get a hold of you?
Yeah. So the best way to get a hold of me is through my cell phone. Okay. It's 828-851-2963. Give me a call, give me a text. Okay. I generally respond within 48 hours, if not sooner. Okay. But that's the way I like people getting a hold of me. Hey, give me a call. Okay. Let's see if I can help out.
Okay, great. And we'll put that cell number in the show notes as well to this. And if you're looking for a reliable property management company, please feel free to reach out to us as well. I'll put our website in the show notes as well. And thank you for tuning in to the Your OKC Property Manager podcast. And don't forget to subscribe and leave us a review, and join us next time for more expert insights on rental property management in the Oklahoma City metro area. Until then, stay informed, stay protected, and stay profitable.